Hello LiveLaw viewers, welcome to Courts Today. Let us dive into the important legal headlines of the day. A Mumbai court has granted bail to men accused of vandalizing the venue where comedian Kunal Kamra performed recently. The Allahabad High Court Bar Association has announced indefinite strike over Supreme Court Collegium's proposal to move Justice Yashwant Varma to the High Court. The Supreme Court has quashed a rape case against a man, noting that the woman willingly accompanied the accused to the hotel room 3 times. The top court has slammed Uttarakhand government for not paying promised ex gratia for a doctor shot dead in a hospital and has now ordered 1 crore compensation. Corp, formerly known as Twitter, has told the Delhi High Court that it cannot be compelled to onboard SAHYOG portal as it has its own mechanism to take down unlawful content. The Allahabad High Court has come to the aid of a male acid attack survivor, asking the state authorities to show due sensitivity in such cases. And the top court has observed that delay in recording witness statements under section 161 or 164 of CrPC is not fatal if there is an adequate explanation. I'm your host Urvashi Chauhan, bringing you the important legal updates of the day, quick, crisp and to the point. Watch till the end, and if you find this update valuable, don't forget to like, share and subscribe. A new controversy has arisen after comedian Kunal Kamra's recent show. He allegedly called Maharashtra Deputy Chief Minister Eknath Shinde a traitor in his skit, likely referring to his split from the Shiv Sena. Although Kamra had not named Shinde in his skit, the references were seen as being pointed directly at the Deputy Chief Minister. After the incident, being enraged by Kamra's remarks, alleged workers of the Shiv Sena vandalized the venue, the Habitat Comedy Club. They completely ransacked it while warning Kamra of dire consequences for his comments. The police had arrested Shiv Sena functionary Rahul Kanal and 11 others, and today a court in Mumbai's Bandra area has granted bail to the 12 men. A separate case has also been lodged against the comedian, which is being investigated by the police. This incident has sparkled mixed reactions on social media, while some argue that freedom of speech should be upheld and that jokes, no matter how critical, should not invite threats or violence. Others believe that Kamra should have exercised more responsibility in his remarks. In the next update, the Allahabad High Court Bar Association has announced an indefinite strike starting today in protest against Supreme Court Collegium's decision to transfer Justice Yashwant Varma from the Delhi High Court to the Allahabad High Court. Justice Varma has been at the corner of a controversy following reports of a fire at his official bungalow on 14th March, which allegedly led to discovery of sacks of cash. News reports claimed that a storeroom at his residence caught fire, revealing large amounts of cash, triggering concerns of financial misconduct. On 21st March, CJI Sanjeev Khanna set up a 3-member panel to investigate the matter as part of the in-house procedure. The inquiry was initiated based on a report submitted by the Delhi High Court Chief Justice D.K. Upadhyay, who recommended a deeper probe. As the controversy escalated, the Delhi High Court withdrew all judicial work from Justice Varma on 24th March following Supreme Court directives. Justice Varma, however, has denied all the allegations, calling them a conspiracy against him. Yesterday, the Supreme Court Collegium officially recommended transfer of Justice Varma to his parent High Court, that is the Allahabad High Court. But the High Court Bar Association is unhappy with the decision. The association has urged the central government to intervene and dismiss the transfer order. In a resolution passed in its General Assembly meeting, the Bar Association expressed a strong opposition, stating that the collegium ignored their concerns. As a mark of protest, they have decided to abstain from judicial work indefinitely. The Bar Association has also informed that the Photo Affidavit Center will remain closed from 26th March. Additionally, it has warned that if oath commissioners and government advocates continue working, the association will not oppose any action taken against them. Last week, when the transfer was recommended, the association had written a letter to the Chief Justice and other judges stating that the Allahabad High Court was not a trash bin and that corruption was unacceptable. The top court has reiterated that a breach of promise to marry does not automatically amount to rape unless there was fraudulent intent at the time of consent. In this case, a man accused of forcing a woman into sexual relations under the pretext of marriage had moved the top court after the Madras High Court refused to quash the FIR against him. The case was filed under IPC sections 376, that is rape, and 420, that is cheating. The woman alleged that the accused had coerced her into sexual intercourse on 3 occasions, promising marriage but later refusing. She claimed that after the first incident where the said force was used, the accused assured her of marriage. Despite feeling distressed, she met him twice more at a hotel where she again alleged coercion. The Supreme Court, however, found that the woman had willingly accompanied the man to the hotel 3 times even after claiming distress. The court noted that there was no evidence of deception at the time of consent, which is necessary to prove rape on false promise of marriage. It noted that the victim had categorically stated that after the first incident and second incident, she was mentally upset, but that did not caution her from again accompanying the accused to the hotel rooms. The bench of Justices Sudhanshu Dholia and K. Vinod Chandran reiterated that for such a case to stand, 2 conditions must be met. First, the promise of marriage must have been made solely to obtain consent for sexual relations with no real intention of fulfilling it. And second, that the woman must have consented to sex only because of this false promise. Since neither condition was met, the court quashed the rape charges, stating that the prosecution failed to prove fraudulent intent by the accused. The appeal was therefore allowed and the case was dismissed. Moving ahead, the top court has strongly criticized the Uttarakhand government for failing to pay ex gratia compensation to a widow of a government doctor who was shot dead while working at a community health center in April 2016. Despite the then Chief Minister approving 50 lakh in financial assistance, the amount was never paid, forcing the doctor's family into nearly 9 years of legal battles. Displeased with the prolonged delay, the top court has ordered the state to pay 1 crore, including interest for the delay. Since 11 lakh had already been disbursed, the court directed the government to pay the remaining 89 lakhs. This case dates back to April 2016 when the doctor was shot dead by assailants while performing his duties. Recognizing the gravity of the incident, the Chief Secretary of Uttarakhand had initially proposed an ex gratia compensation of 50 lakh, which was approved by the then Chief Minister. However, the amount was not paid, with the government citing procedural hurdles. The widow of the doctor approached the Uttarakhand High Court, which in 2018 directed the government to pay 1.99 crore in compensation along with 7.5 interest per annum. The High Court also instructed the state to implement the Uttarakhand Medicare Service Persons and Institutions Act 2013 to ensure protection for healthcare workers. Additionally, it directed the government to release extraordinary pensionary benefits to the doctor's family. After the state's review petition was dismissed in 2020, it filed the SLP before the Supreme Court, challenging the High Court's order. Before the Supreme Court, the Uttarakhand government contended that the doctor's family had already received various benefits, including leave encashment, family pension, gratuity, and employment for the deceased's son in the health department. The state also urged that the High Court's use of multiplier method to compute compensation was not legally sustainable. But the Supreme Court rejected these arguments, stating that the approved ex gratia compensation should have been honored and that the family should not have been forced into prolonged litigation. The court said that government's failure to fulfill its commitment was a serious lapse and has now ordered immediate payment of 1 crore to the family. The court has now scheduled the next hearing in this case for 22nd April. Stay tuned. In the next update, Corp, formerly Twitter, has told the Delhi High Court that it cannot be forced to onboard the SAHYOG portal, a platform designed to facilitate coordination between law enforcement agencies and social media intermediaries for swift action against unlawful online content. The SAHYOG portal aims to streamline the process of sending takedown requests to social media companies, ensuring a safer cyberspace for Indian citizens. However, Corp has urged that it already has its own portal to handle legal requests and that SAHYOG falls outside the statutory framework of Section 69A of the IT Act. The company contends that SAHYOG would create a parallel system without legal safeguards, potentially bypassing the existing mechanism under Indian law. A division bench of Justice Pratibha M. Singh and Justice Amit Sharma recorded Corp's position while hearing a habeas corpus petition filed by a mother seeking whereabouts of her missing 19-year-old son. The Indian Cybercrime Coordination Center, also known as I4C, which handles cybercrime complaints, has expressed concerns over Corp's lack of cooperation. It informed the court that in previous cases, including those related to child sexual exploitation and abuse material, Corp had failed to respond to law enforcement requests. I4C has now insisted that Corp must onboard SAHYOG just like Google, Telegram, YouTube and others that have already joined, while Meta-owned platforms like Facebook, Instagram and WhatsApp are in the process of joining. The court emphasized that all platforms must cooperate with law enforcement agencies, particularly in cases involving missing persons, security threats and serious crimes. In a related development, Corp has filed a petition before the Karnataka High Court seeking protection from any coercive action against the company, its representatives or employees for not joining SAHYOG until a final decision is made on its petition. The Delhi High Court will hear this matter now on 29th April. Stay tuned. In another update, the Allahabad High Court has ordered the District Magistrate of Hapur to immediately process and release ex gratia amount under Prime Minister's National Relief Fund to a male acid attack survivor within 4 weeks. A division bench of Justice Ashwini Kumar Mishra and Justice Arun Kumar Singh Deshwal stressed the need for state authorities to act with sensitivity in cases involving acid attack survivors and expressed concern over the delay despite the existence of a central government scheme for such victims. The petitioner here, named Aslam, was 27 years old when he suffered a brutal acid attack in November 2016, which resulted in severe injuries and 100% disability. He later applied for financial assistance under the central government's welfare scheme for acid attack survivors. Despite a clear directive from the central government in May 2024 instructing the district magistrate Hapur to verify and process his claim, no action was taken. Left with no other option, Aslam approached the High Court for relief. The High Court observed that officials must handle such cases with urgency and sensitivity. It has directed the Hapur DM to verify the petitioner's claim, process the ex gratia amount as per the scheme, and release the amount within 4 weeks. And lastly, the top court has ruled that a delay in recording an eyewitness's statement does not automatically weaken the prosecution's case if the delay is properly justified. A bench comprising Justices Abhay S. Oak, Ehsanuddin Amanullah, and A.G. Masih upheld the conviction of the appellants here under Section 302, that is for murder, read with Section 34, that is common intention, under the IPC. Their argument that the delay in examining eyewitnesses created doubt about the prosecution's case was rejected. The appellants had contended that the eyewitnesses in this case were examined 3 to 4 days after the incident. It was contended that as per the 1978 judgment in Ganesh Bhavan Patel versus State of Maharashtra, Supreme Court had held that delays in recording statements could be detrimental to the prosecution's case. However, the state explained that the delay was due to the investigating officer's involvement in maintaining law and order in the area which had been affected by riots. The Supreme Court has now observed that when a delay in recording witness statements is satisfactorily explained, no adverse inference should be drawn against the prosecution. The court referred to the 2013 judgment in Lal Bahadur versus State, that is NCT of Delhi, where a 27-day delay in recording witness statements was found to be justified due to communal violence in the area. It further noted that the Ganesh Bhavan Patel judgment would not be treated as a strict precedent in this case, as the ruling involved not just a delay in recording witness statements, but also a delay in filing the FIR, which raised doubts about the prosecution's case. The bench emphasized that there is no rigid rule on this issue and each case must be evaluated based on its specific circumstances. Since the prosecution in this case had adequately explained the delay, the court refused to interfere with the conviction and dismissed the appeal.